Now it is visible. Thank you so much. Everyone, is the screen visible to you? Can you see the handsome face of Mr. Shamil, who is going to address especially the some new kind of things and especially the regulatory part under the CLRA? Thank you, everyone. Thank you, Ruin. Okay. So now over to you.
Yeah, yeah. So first of all, let me introduce myself. I am Mohammed Shamil, and I am the Director and Principal Consultant for Dictaminate. I am a law graduate, having almost more than 18 years of service in the labor law compliances and other allied activities. So today, I am going to conduct a class on the topic Practice Guidance on the Redefined Contract Employees. This class is being divided into 6 parts. So first part is with regard to the closing of loopholes of the CLRA Act and a new definition of the contract employees in the labor code. See, as per the old act, the CLRA Act was applicable to those establishments where 20 or more contract workers were employed. Now, as per the new code, as everybody knows, it is applicable to those establishments where 50 or more contract employees were working in the establishment. If there are 50 or more employees working with the establishment, contract employees working with the establishment, then this code, new Occupational Safety, Health and Working Condition Code, will apply. And with regard to the definition of the contract labor, the scope of contract work, it covers all the contract workers, including those hired through contractors, regardless of whether the principal employer was aware of the arrangement. As per the old act, the definition of contract labor is that it covers all the contract workers, including those hired through contractor, with or without the knowledge of the principal employer. As far as the new code is concerned, there is slight inclusion and exclusion in the present code. As per the new code, the contract labor includes interstate migrant workers as well. Earlier, there was some confusion whether the interstate migrant workers will come under the contract labor category. Now it has been cleared, so that loophole has been closed. So as per the present code, it includes interstate migrant workers. Now there is one exclusion. This is very important. This is very, very important as far as the CLRA Act is concerned or the new code is concerned with regard to the definition of the contract labor. It excludes those who are permanently employed with the contractor and receives periodic increments, social security benefits, and other employment protection. So there is an exclusion. It excludes all the permanent employees who are permanently working with the contractor and receiving periodic increments and getting all the social security benefits which a permanent employee should get. So that permanent employee has been excluded in this definition. So according to me, even though it says that it is closing of the loophole, according to me, this definition or this exclusion is an opening of a new loophole. It may lead to litigations. See, if this exclusion is come into effect, then the main purpose of this provision or the main purpose of this code, as far as the labor law is as far as the contract labor is concerned, may fail. See, if this inclusion has been included, if the inclusion has been there in the the exclusion has been there in the contract labor definition, the principal employer may ask the contractor or the contractor to supply only the permanent employed person. The principal employer may ask the employer or the contractor to employ only the permanently employed person who is getting periodic increments and who is in a permanent nature. This will defeat the purpose of this act. I am sure that there will be two contradictory views on this exclusion. The one view is that it excludes only the contract employees who are permanently employed in the establishment of the contractor. The establishment means who is having the ultimate authority on that establishment, on the premises. For example, if a contract is working in the premises of the contractor, and if that employee is a permanent nature, then that employee can be excluded. But if a contract employee is working in an establishment where the ultimate control over that establishment is the principal employer, then this exclusion will not come into picture. even then, if the contract labor is working in establishment under the control of the principal employer, where the contractor does not have a control, then this exclusion cannot be considered as a contract labor. Number one. Number two, the view is that those employees who are working permanently with the contractor, whether even if the contract employees are working in the premise of the establishment or in the premise of the principal employer or in the premise of the contractor, then that contract employee is excluded. So this exclusion can lead to several litigation. So according to me, my view is that if the contract workers work in establishment under the control of the principal employer, whether the working location is under the control of the principal employer, then principal employer is on the control of the establishment or the establishment location. The location is very important. So according to me, if the contract employees are working in an establishment under the control of the principal employer, then even if that contract labor is permanently employed with the contractor, that contract employee will also come under the definition of contract labor under the code. That's my view, because I have taken this view only because if it is the other way, the main purpose of this code or the definition will be defeated. So according to me, the permanent employee, according to me, the contract labor can be excluded only if the contract employee is working in the premises under the control of the contractor. Then only the exclusion will happen. In the other way, there is no exclusion. Even if the permanent employees are working with the contractor in the premise of the principal employer, then the contract labor can also termed as contract labor in the definition. So there is no exclusion. That's my viewpoint.
Attention everyone, this is the very high motivative, the session started and opening by Mr. Muhammad Shamil. So your thumbs up required here. However, I cannot see any thumbs up for Mr. Shamil. So please, your participation is highly appreciated to give the thumbs up and your tone here, so that next we can move ahead. Quickly. Either it is, yeah, very good. Give your thumbs up, go to screen, give to heart, just in a few 10 seconds. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Very good, everyone. Keep going. Shamil, Dr. and Mr. Shamil, please keep going.
Yeah. Then with regard to the registration part, as per the old act, the principal employer as well as the contractor has to register with the labor department within 60 days of the starting of the contract work. So as per the earlier act, the principal employer as well as the contractor has to register within 60 days from the starting of the contract work. But in the new code, the contractor has to register before starting the work, and the principal employer should appoint only those contractors who are having a registration prior to the starting of the work. So there are two types of registration. One is centralized registration. If there are multiple locations, the contractor can take central registration, and the license. There are other options where the labor department may give the license for 1 year or 5 years, the case may be. So as per the new code, a contractor cannot work in an establishment, or the principal employer cannot employ a contractor without a valid registration certificate or valid license. So this is the advantage which the principal employer is getting as far as this code is concerned. So it is a good loophole on the part of the principal employer, and the loophole is closed. So this clause is advantage to the principal employer. Moreover, in this new code, the principal employer is not required to take registration. Only the contractor is required to take registration. Then point number 4, salary payment. In the old act, it is the responsibility of the contractor to pay the salary, and if the contract does not pay, then the principal employer has to pay. The only condition is that during the period of payment, the principal employer should be physically present at the time of payment of salary, which is practically impossible in the present scenario. Even that the present CLR Act says that the principal employer should be present at the workplace during the time of payment. But now there's a slight change in the new code. So the loophole has been closed as far as the salary payment is concerned. It says that even though the principal employer is liable to pay salary if the contract does not pay it, but the contractor can pay the salary on an online mode. The only condition is that the principal employer must be informed about the payment status. So that loophole is closed. So principal employee is irresponsible. The contract, first the contractor is responsible, then the principal employee is responsible, and the contractor should inform about the payment to the principal employer. Then the next point is with regard to the welfare provisions. As per the old act, the contractors were responsible for providing welfare facilities such as canteen, restrooms, drinking water, latrines, urinals, and first aid facilities. As per the previous act, the welfare provision is under the responsibility of the contractor. But here, the loophole is clearly closed. It is advantage to the workers. It says that now the principal employer is responsible for ensuring proper health, safety, working condition, and welfare provision. So that loophole is closed as far as the contract labor is concerned. It is advantage on the part of the contract labor since it is the responsibility. The code has made the principal employer to responsible, or the principal employer is now responsible for ensuring the proper welfare provisions. That is advantage for the workers. Then, as per the old act, the contract labor could be engaged in all the establishment unless restricted by specific order. As per the old act, the contract labor is entitled to be employed in all the establishment irrespective of the establishment. But the only thing is that unless restricted by specific order, if there is a specific order, the contract labor cannot be employed. But that loophole has been closed. It has been clearly closed, and it is the advantage for the workmen. The contract labor cannot be engaged in a core activities or activities that require full-time employment or where the company's core business is involved. Where the core business of the company is, for example, if you are taking an IT sector, if the main core business of the IT sector is the software development. So the software development is the core activity of the employer. So if you are employing or if you are outsourcing that particular work to an outsourced partner, to a third party, then it is not permissible as per the new code. So this loophole has been closed, and this loophole is advantage to the workmen. It prevents misclassification of full-time jobs as contract workers, ensure that core business functions are handled by permanent employees, increasing job security. The job security of the workmen will be increased, limits the flexibility of the employer in managing workforce requirement. So that is the benefit for the workman. Then, and the important rule change is with regard to the bonus payment. As per the old act, the principal employer was not liable to pay bonus unless they specifically agreed upon the contract. If as per the agreement between the contractor and the principal employer, if the principal employer agrees that the payment of bonus is on the principal employer, then the liability will be on the principal employer as per the old act. But that the responsibility is now shifted to the principal employer. So if the contractor fails to do so, or if the contractor fails to pay the bonus, that is very important. This one is a perfect or a good example of closing the loophole. So principal employer is now liable to pay bonus if the contractor is not able to pay it. So the liability is on the principal employer if the contractor does not pay it. So this is also advantage for the employees. It ensures the workers receive bonus even if the contractor defaults. So it is advantage for the employees or the workers. Then last point, gratuity payment responsibility. It's a hot topic as far as the old act is concerned or old gratuity act is concerned. There was ambiguity whether the responsibility is on the principal employer or the contractor for the gratuity payment. Several high courts have said that the principal employer is liable for gratuity payment. Some high courts have clearly said that the contractor is liable. Even my state in Kerala has clearly stated, or the High Court in Kerala in 1972, you have to check that judgment 1972, somewhere in that during that period, there is High Court order which says that the principal employer is not liable as per the order. But that ambiguity, that loophole is closed as far as the new code is concerned. Now the new code clearly states that the contractor is responsible for gratuity payment because the gratuity has been excluded from the wages definition in the code. So that is the reason the new code clearly says that contractor is responsible for gratuity payment. So this is advantage for the principal employer and disadvantage for the workman. So the loophole is advantageous or more beneficial to the principal employer, and the loophole is not beneficial to the contractor, to the employees, contract employees. Then, then the next part, how to determine whether the employees are genuinely outsourced and new outsourced employee conversion. Here, how we will be able to know or how we will be able to determine whether the employees are genuinely outsourced. There are certain tests to be followed to see that or to test whether the employees are genuinely outsourced. The first important test is who controls the work. This is very important. Who is controls the work? Who is controlling the work? The contractor should assign task, monitor performance, and issue work instructions. It is the responsibility of the contractor to see that the work has been assigned to the contract laborers, and the contractor should monitor the work performance, and issue that work instructions. And if the principal employer gives or assigns tasks to the contract laborers directly, there indicates an employment relationship between the principal employer and the contractor. Principal employer and the contract employee. So direct employment by the principal employer should not happen. This what is the test called the who controls the work. Who is controlling the work? That is the first test to determine whether the employees are genuinely outsourced. The second one, who supervises the work. The contract manager supervisor should handle day-to-day oversight. Contracted or the managers or the contract supervisor should handle the day-to-day activities of the contract laborers. The supervision by the principal employer weakens the outsourcing claim. The principal employer supervision will weaken the outsourcing claim. That means that if the principal employer supervises the work, then it can be seen that the employees are not genuinely outsourced. So 2 points are very important: who controls the work and who supervises the work. If the controlling and supervising is done by the contractor or the contract manager supervisor, then it is a genuinely outsourced employment. And if it is controlled and supervised by the principal employer, then you can clearly say that the employees are genuinely not outsourced. Then the third point is core and not core work. Outsourcing should focus on not core work, that is housekeeping, security, etc. Core business functions such as IT department should not involve contract workers. This is very important. For not core activities, the employer can employ the outsourced employees. For non-core activities such as housekeeping, security, back-end services, all these things are non-core activities. And the new code clearly says that the contract labor cannot be employed on a core work activities. That is already explained in my previous slide. So for core activities, there should not be any outsourced workers, and for non-core activities, you can have outsourced workers. For example, if you are an IT company or a software company, then the main core activities of the IT company or the software company is the software development. So you cannot employ a contract worker or contract employee on the software development area. So software development area has to be done by the direct employees. Then the next test to determine whether the employees are genuinely outsourced is specialized and routine work. Specialized work supports genuine outsourcing. Specialized work supports genuine outsourcing. Routine business critical tasks could be challenged as discussed employment. So specialized work has to be done by the genuine outsourcing, or if your company is having a specialized work which cannot be done by the permanent employees, an expert is required for employing this specified work, then you can appoint a specified contract or you can outsource the specific contracting. For example, in my case, if you are a company and you can outsource a consultant for HR compliance or HR related compliances. So HR related compliance is an expert or a specified job. So that type of job you can employ an outsourced employee or an outsourced person. The routine business critical task should be done by the permanent employees. So that cannot be outsourced. Then let us move to the next test to determine whether the employees are genuinely outsourced. Then determining whether the employees are genuinely outsourced and new outsourced employee conversion. Payment and benefit. This is very important. Payment and benefit. Wages should be paid by the contractor and reimbursed by the principal employer to the contractor. It should be the responsibility of the contractor to give the benefits and salary to the contract employees. And it can be, of course, it can be reimbursed from the principal employer, but the first payment has to be done by the contractor, or the first payment should be done from the contractor's end. All the benefits and payment and all the benefits such as ESA, PF, gratuity, everything, all the statutory benefits should be handled by the contractor. The ESA, PF, all the things should not be handled by the principal employer directly. It has to be handled by the contractor. The principal employer does not have any say on the statutory benefits. The only thing the principal employer can audit that whether the contractors are doing this or giving the statutory benefits. That is the only duty of the principal employer. So all the statutory benefits should be handled by the contractor. Then, appointment and termination authority. Contractor should handle hiring, disciplinary action, and termination. So this is another very important test to determine whether the employees are genuinely outsourced. Who is giving the appointment? Who is giving the appointment? Who is selecting the contract laborers? Who is taking the disciplinary action against the contract laborers? If any contract laborers do any wrong thing, who is taking the disciplinary action? Who is terminating the contract employees? This test is another important test as far as the genuinely outsourced determination is concerned. So contractor should handle hiring, disciplinary action, and termination. The principal employer should not handle hiring. The disciplinary action should not be taken by the principal employer. The termination should not be done by the principal employer directly. So direct involvement by the principal employer suggests an employment relationship between the contract laborer and the principal employer. And the last one, the exclusive services. If the worker services multiple clients through the contractor, it supports outsourcing. Exclusivity with a single principal employer for an extended period could determine the outsourcing claim. So if the workers are serving the multiple clients through the contractor or to the same contractor or different contractor, it supports outsourcing. In exclusivity with a single principal employer for an extended period could undermine the outsourcing claims. So that is also very important. So these are the 6 steps or tests which we can determine whether the employees are genuinely outsourced. So these are the very important tests which will help you to determine whether the employees are genuinely outsourced. Then I am going to the part number 3, that is alternative pathway to outsource conversion. Here we will look into the aspects. What are the alternative pathways to outsource conversion? What are the alternative methods to outsource the contract laborers or outsource the work? First one is the fixed term contract. The fixed term contract directly engages worker under a fixed term. Here the fixed term contract, here you can, or the principal employer can employ a worker or employee on a fixed term contract. Here the principal employer is directly appointing the employees for a fixed term. The fixed term may be for 1 year, 2 years, or 3 years, as the case may be. So the principal employer can directly employ a contract, or the principal employer can directly engage a worker under a fixed term contract. The fixed term employees are entitled to pro-rate statutory benefits. The fixed term employees are entitled to pro-rate statutory benefits such as ESA, PF, and bonus. Wherever the direct fixed term employees are working for a specific period, only for the specific period you have to pay the ESA and PF. The advantage with the fixed term contract is that immediately after the completion of the contract, the principal employer can terminate or end the contract with the employee. So that is an advantage for the principal employer. So there's no liability on the principal employer to pay the gratuity unless the contract exceeds 5 years in the old act. As per the old act, the gratuity is applicable only if the contract is extended more than 5 years. If the contract extended for more than 5 years, even if it is for fixed term contract as per the new act or as per the old act, the gratuity is payable only if there are or if the contract exceeds 5 years. But in the new act, this is another important aspect. It's also an important aspect of closing the loophole. In the new act, even the fixed term contract employee can also or are entitled to gratuity provided minimum 1 year should be completed by the contract employee or by the fixed term contractor or the contract employee. Fixed term contract employee should, even if he is completing 1 year, minimum 1 year, then the gratuity is applicable as per the new code. That is a very important loophole which has been closed, and it has advantage on the part of the fixed term employee. Then project based contracting. Hire for a specific project with a defined start and end date. You can employ a contract employee for a specific period, and this period should definitely contain a start date and end date. In the contract, it should be specifically mentioned that there should be a start date and end date in the project for a specific project. And the payment ties to project completion, not employment duration. The contract employee will be paid the salary or wages or remuneration only after completing the project. The employment duration is immaterial in this project-based contracting. So the payment has to be made only after the completion of the project. The completion of the project is made more important than the employment duration. Then project-based contracts prevent the employee from claiming permanent status as the engagement ends with the project. In the project-based contracting, the principal employer or the employer can prevent the employee from claiming the permanent status as a permanent employee. You need not provide permanent status to a project-based contracting employee. So this is advantage, or this is an alternative path to outsource conversion. First one is the fixed term contract, then second one is the project-based contracting. Then let us go to the third pathway. The third pathway for alternative outsource conversion is third-party contracting. This everybody knows. Today, all the principal employers are doing the same pattern, or they are doing, or they are employing the contract on a third-party role. Here, as per this pathway, engage a staffing agency to manage contract workers. As per this, the principal employer can engage a staffing agency to manage the contract workers. The agency handles payment, supervision, compliances. The agency will handle payments, supervision, and compliances. Ensure the contract is licensed and compliant with the labor laws. The principal employer should ensure that the contract is licensed and the contract is compliant with all the labor laws. So clearly define the scope of work, duration, responsibilities in the contract. In the third party contracting, there should be clear definition of the contract. What are the scope of work? What are the duration? What are the roles and responsibility of the contractor as well as the contract employees? That has to be specifically mentioned. And the last one, it is not a common pathway to outsource conversion. It's not an alternative. It's not a common pathway. It's a new system where it is outsourcing to a professional employer organization. The PO manages HR, payroll, and compliance. The third-party contracting is a separate entity. It is given to individual company, but here this outsourcing is given to the professional employer organization, an employer organization where other employers are the members of the organization. You can have a separate organization structure, or the employer can have a separate organization or association, and the association should manage HR, payroll, and compliance. It will shift employer obligation to the PEO. The PEO become the legal manager while the employee work for the client company. The PEO become the legal employer while the employee work for the client company. This shifts employer obligation such as ESC, APF, and other statutory things to the PEO, reducing the legal risk of the principal employer. So these are the for alternative pathway to outsource conversion. Now, let me go to the point number 4 or part 4 of this class. That is contract information statement. It is the contract information statement. Let us analyze the purpose of the contract information statement. To provide details about the contract labor engaged by an establishment. The purpose is to provide details about the contract laborers engaged by an establishment. Then now analyze what are these things or what are the details which has to be mentioned in the statement. The statement must include the name and address of the contractor, the name of the contract workers engaged. It should contain the name and address of the contractor, what are the nature of work and the number of contract workers engaged. What are the nature of work performed by each contractor? If there are multiple contractors, you have to mention the different types of contract work done by the contract employees. What are the rights and duties assigned to the contract employees? That is also to be there in the contract information statement. Then wage duration of the contract. There should be duration of the contract. The duration of the contract should be mentioned in the statement. Then what are the wages and benefits provided to the contract workers? The contract information statement should contain the wages and benefits provided to the contract workers. That also should be contained in the contract management statement. So let me move to the next point, that is benefits. Contract information statement. Benefits. Enhance transparency in contract labor arrangement. The contract information system enhances the transparency in contract labor engagement. It enhances the transparency of the contractor. Helps prevent exploitation of the contract workers. If all the nature of work has been clearly defined in the contract information statement, then we can prevent the exploitation of the contract workers. The contract workers will not be exploited by the employer. It facilitates compliance with labor law and inspection. It will reduce the compliance burden on the principal employer. It facilitates compliance with labor laws and inspections. Then, let us go to the practical guidance for contract information statement. Practically, what has to be done while preparing the contract information statement? First one, maintain accurate records of contract workers and their details. You have to mention the accurate record of contract workers and the details. All the details and the record of the contract workers has to be maintained in the contract information statement. Ensure the statement is submitted within the prescribed time frame. You have to make sure that the contract information statement is being completed or given to the employer within a prescribed time frame. The information in the contract information statement should be prescribed or presented within a time frame. It has to be prepared within a time frame. Immediately when you are giving a contract, immediately you have to enter the details in the contract information statement. And you have to use the contract information statement to demonstrate compliance with labor laws. To ascertain the compliance with the labor laws, the contract information sheet will be helpful for the for the company. So these are the practical guidance for contract information statement. Now let me mention that now there is only 2 chapters to be discussed. Then I am going to the 5th chapter, second last chapter, which is preventing double dipping concern for outsourced employees to claim both casual loading and permanent entitlement. First, we have to ascertain what is double dipping concept. Double dipping process is double dipping is a process by which the outsourced employees claim both the casual status as well as the permanent status. That is what is called double dipping. When the outsourced employees claim both the casual status as well as the permanent status, that is called double dipping concept. What are the steps to be taken to prevent the double dipping concern? Number 1, Check if casual employees work regularly, systematic hours. If so, consider offering them permanent roles. If the casual employees are working on a regular basis in a systematic hours, then consider offering them a permanent role. This will prevent the double dipping issue as far as the casual workers are concerned. So consider offering them a permanent job. Consider the casual employees to offer them a permanent job. Then next one, comply with the laws requiring casual to permanent conversion after a certain period. After a certain period, if the casual employees are converted to permanent employees, then you have to comply with the rules and regulations as far as the permanent employee is concerned. When the status is converted to permanent employment status, then you have to comply with all the labor laws applicable to the permanent employees. Explain to casual employees that their higher pay compensates for lack of permanent benefits. You have to explain to the contract employees that or the casual employees that you are getting higher pay. If you are getting a higher pay or if you are providing higher pay to the casual employees, then you have to make sure that or you have to explain to the casual employees that you are getting higher wages or higher pay compensation for lack of permanent status. Since you are not getting a permanent benefit, that is the reason for the time being you are paid higher wages. Then that explanation should be incorporated in a written agreement between the casual employees and the employer. There should be written arrangements. Written acknowledgement should be there as far as the casual work status is concerned. Then, next point. Engage casual workers for irregular short-term work with no guaranteed hours. You have to engage casual workers for irregular if the work is for irregular nature, if it is for a short duration, or it is for a short period, if there is no guarantee working hours, if there is no guarantee working hours, if it is the project is for a short period and it is for irregular period, then you can engage a contract labor. This will prevent double dipping concerns. And hire the contract workers through a contractor. You have to hire the contract workers through a contractor for a specific task or duration. Then you have to give or the permanent workers are entitled to benefits like paid leave, gratuity, provident fund. You have to give all the permanent benefits to the permanent workers. Just to be clearly define the employment type in the contract and ensure compliance with the labor laws. If you are employing a permanent worker, the employment type should be there in the contract entered between the worker and the employer. Just to be clearly defined about the nature of employment or the type of employment. It has to be defined in the contract agreement. Then ensure compliance with labor laws which regulates contract labor and prohibits their use in core activities unless explicitly allowed. You have to make sure that the casual laborers are not employed in your core activities. What are the core activities? What are the example of core activities that I have already explained? So you can verify it. So the casual workers should be made to work only on a non-core activities. The casual employees should be made to work for a non-core activity that is already discussed. Avoid misclassifying permanent workers as casual or contract workers to deny benefits. There are some tendency on the part of the employer to misclassify the permanent workers as a casual laborer. They will make the permanent workers to work as a casual laborer so that or to deny the worker the benefit. That should not be happen. That should not happen. So there should not be any misclassification of permanent workers to casual workers and vice versa. And misclassification should not be there for vice versa provisions also. Ensure the contractor, not the principal employee, to manage attendance, control work schedule, and handle discipline. This has already been discussed in my previous slides, so I am not going through it in detail. So the principal employee need not maintain the attendance. The control should be there from the contractor, and this will prevent the double dipping concern for outsourced employees to claim both casual loading and permanent status. Contractor casual workers performing the same work as permanent employee must receive equal wages and benefits. This is very important. Equal pay for equal wages. Sorry, equal pay for equal work. If you are paying or if you are giving same work to casual laborers and permanent employees, then equal pay to equal work. If you are having same work culture or you are giving same work to both the casual employees as well as the permanent employee, then you have to pay equal wages and benefits. You have to equally pay wages for equal work. So these are the points which help us to prevent double dipping concern for outsourced employees. Then I am going to the last chapter or the last point which I am going to discuss in this webinar or in this conclave. This is the final one. So I request all of you to be ready with the questions. If you have any questions, you can ask after this slide or after this chapter. Since my time is already over or it's going to over, I am little bit fastening my approach. I am little bit in a 100 gear. So I am moving in a 100 gear.
Not an issue. Carry on. So we will extend a little while, maybe around 13:10. So another speaker would be Dr. Nepal Singh. We have two doctors here today. They are not
Okay.
the medicine doctor. They are the academic doctor and renowned people. So
Okay.
we can extend it till 13:10, means 1:10. We will start the another session
Okay.
there.
That means I have
So yeah, 10
10
minutes
more.
we can go there with the question and answer, and then 1 minute I will pick up for
Yeah.
the group photographs and sharing on the LinkedIn, so that all that we can get connected to you also. Please carry
Fine.
on.
Fine. So this is my last, final, and very important 5 minutes. Let me discuss about the tips for amending employment agreement for outsourced employees. What are the tips to be taken into consideration while amending the employment agreement for outsourced employees? What are the points to be taken into consideration for amending the employment agreement for the beneficial of both the contractor as well as the principal employer? Define the nature of the work or define the nature of engagement. State whether the work is a direct employee, a fixed term contract, or outsourced. In the agreement, you have to clearly mention that clearly mention the nature of engagement, whether the workers are directly employed or not, whether it is fixed term contract or it is outsourced. That has to be clearly mentioned in the agreement between the contractor or the contract employee and the principal employer or the employer. Clarify the employer-employee relationship. Specify that the worker is hired through a contractor. If the worker is hired through a contractor or through a third party vendor, it has to be clearly mentioned in the contract that the contractor will be hiring the contract laborers on behalf of the principal employer. There should be clarity between the employer-employee relationship. There should not be any employer-employee or direct employer-employee relationship between the contract laborers and the principal employer. That is very important. So that you have to take into consideration. Then clarify wages and benefits responsibility. The agreement you have to clearly mention or clearly state who is responsible for paying the wages and benefits. You have to clearly mention that the contractor is responsible for paying wages, bonus, and statutory benefits such as ESA, PF, and other allied compliances or benefits. You also have to add a clause to protect your company if the contractor fails to comply. In the agreement, there should be a specific clause which will protect the company or the principal employer if the contractor fails to comply. That is very important. That is for the beneficiary of the employer or the principal employer. You have to make sure that the statutory benefit, the primary or the first responsibility will be or should be given to the contractor. So you should state that the contractor is responsible for paying wages, bonus, and statutory benefits. Then, fourth one, confidential and non-compete terms. Make sure confidentiality and non-compete clause apply to outsourced employees. In the agreement, there should be a confidential clause which says that the contract laborer should not disclose confidential matters to a third party. That is very important. Sometimes the contract employees may say so many confidential matters or policy decisions or policy matters or trademark issues or some or some important activity which is a core activity of the company. So the contract laborers may breach the confidentiality. So that clause has to be there in the agreement. So data protection clause should be there in the agreement. Then termination exit terms. Ending the contract with the contractor should create direct employer obligation. So here, as per the contract or in the contract agreement between the contractor and the principal employer, there should be the termination clause in exit process. There should be the exit process or termination of the contract as well as the termination of the contract work. In the contract agreement, ensure that it has to be clearly mentioned that when the contract is going to end, what are the exit terms and conditions, and what after the terms and after the agreement exit or agreement ends, what are the terms and conditions even after the agreement, that is also has to be mentioned in the agreement, and include liability and indemnity clause. Make the contractor responsible for any misconduct or contract breaches by the outsourced employee. In the contract agreement, you have to make the contractor responsible for any misconduct or contract breaches by the outsourced employees. If the outsourced employees give any, what to say, misconduct or contract breaches, then the responsibility should be on the contractor. That specific clause should be there in the agreement. That agreement also contains a clause to cover financial and reputation damages. If the contract labor damages the reputation, and if there is any financial implementation as far as the principal employer is concerned, then that financial implementation or damages should be there or clearly mentioned in the agreement. For example, if so and so things have been done by so and so outsourced employees, then so and so is the financial damages, and so will be the reputation damages. That has to be clearly mentioned in the agreement. Then this is my final slide. So this is the final tips for amending the employment agreement for outsourced employees. Prevent double dipping. The double dipping concept is already explained in my previous slide. So add a clause stopping outsourced employees from claiming benefits from both the contractor and your company. You have to make sure that in the agreement you have to mention a clause that double dipping is not permissible under this agreement. So that is also important. Then last final point which I am going to take in this webinar or in the conclave is follow legal and regulatory rules and communicate with the contractor. You have to follow the rules and regulations, and it has to be communicated with the contractor. Ensure compliance with local, state, and central laws. You have to make sure that in the agreement it is clearly mentioned that the compliance part will be on the contractor, or the onus for the compliance will be on the contractor, and the contractor has to comply with all the state, central, and local laws. Next one, review the original contract and any service level agreement on a periodic basis. You have to review the contract, or you have to review the contract agreement on a periodic basis. If there is required an amendment, it has to be done on a periodic basis. There should be separate audit or periodic review should be there on the original contract. And if there is any change, discuss the change with the contractor. You get the consent from the contractor. You negotiate with the contractor. Only after that, only after the contractor permission only, you can review or you can amend the contract and get their agreement before implementing amendments. Before implementing the amendments, you get the agreement or consent from the contractor. You have to get, or the contract agreement should be validated, or it should be signed and executed properly. Then only you have to take care of the amendments. So these are the tips for amendment or for amending the employment agreement for outsourced employees. So hope everybody enjoyed this section, and I am very much grateful for people manager for giving this opportunity to highlight all this topic. I hereby welcome all the questions which the members is having.
Thank you so much, Mohammad Shamil, briefing and giving the detailed outcome on the outsourced workforce, how the industries, or especially to the HR professional, they can assure there should not be any glitches between the direct and indirect employee. However, there are the many other aspects which has been you beautifully defined between the old the CLRA Act and the new codes, how it is going to giving some advantage to the employer. Now, as in the protocol we have been shared, so kindly can you put down this slide as of now, so
Yeah.
that I can capture the picture of everyone's, then you can share. So please, everyone, please come to the screen just for 30 minutes, and then after we are going for the question and answer session. So here I can see only 12, 15. There are more another people. Please, 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 everyone, come to the screen. Okay, this is the first shot have been taken. Who are on the WhatsApp group, they can see it right away. And the other people, please come to the screen, and then I'm going to get the another shot. So there are the around 14, okay, 16. Please, all other come to the screen quickly. Yeah, good, 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 everyone. Thank you so much. This is enough. So the second screen I have been taken off, and now you are free to off your screen. And now the screen is again to Mohammed Shamil to taking up some questions. And however, it is the 1 9 for 3 and 4 minutes. We are extending this with the question, and then I would like to welcome Dr. Nepal Singh, who is going to help you through, especially to where are the flexible arrangements you have to arrange an organization if there any and that dispute, how you can deal with. That are some practical experience being introduced, shared, and giving you the actionable idea on those constraints. And now just a question answered with Mohammed Shamil, then we are moving to the next session, that is with Dr. Nepal Singh ji. Please carry on.
Yes, sir. Am I audible?
Yeah.
Yeah.
Sir, the first thing is you are saying that the contractors which they are paying for some periodical increments. What is the periodical increments? What is the timeline? What is the periodical time for
See,
increments?
yeah, periodic increment means as per the company policy, maybe some company may give increments, salary increments after 1 year or after 6 months as per the contract. So if you're giving an increment or you're giving additional benefits, permanent benefits to the employees, then that employee can be excluded. Or if they permanently employed, then the employee can be excluded. That's what the code says. But I have a different view that I have already explained.
May I ask you one question, sir?
Yeah.
You have mentioned there the permanently employed with the contractor. Those individual permanently employed with the contractor,
Yeah.
they can be excluded. But
Yeah.
how we may, as the employer, we may able to understand whether the person is permanently employed with the contractor and not.
Yeah. No, see, that's why the code says that if the permanent employees are given increment or other benefits which an original or the permanent employee is entitled, then that employee can be excluded. But the thing is that I have taken a clear note that if the contract employee or the employees who are working in the premise of the principal employer who is having the control, that is very important. Otherwise,
Exactly.
the purpose will be defeated. So
If you just consider, sir, if you just consider some supervisor is deployed in my premises,
okay.
being a contractor employee, and
Uh,
he also having many other assignment as well. So
yeah.
whether I will consider him as a permanent employed of the contractor, or it will be in my role through this contract registration act.
See, for example, if the supervisor is supervising the exclusive work of the principal employer for the particular principal employer, then that supervisor can also come under the scheme, come under the definition. But if that supervisor is working for different principal employer simultaneously, for example, morning he may come and again he may go to some other principal employer afternoon. So that type of supervisor can be excluded.
Okay.
Is there any further questions? So there are only 2 minutes with Mohammed
Yeah,
Shamil to have
Jatin.
question. Yes, please.
Yeah, I have a question here. Suppose like I'm working in an HSBC, I'm just taking a name or in a company.
Okay.
So we have outsourced from a B company for a 1 year contract. Like this
Hmm.
individual employee has a 1 year contract with the principal employer and is working at a company called A. So if employee avail to, I mean, during this 1 year, if employee in a family way and wants to avail a maternity benefit, whether individual is eligible, if eligible, then who has to, who is liable, like an employer A or the principal employer?
See, as far as this is concerned, there are certain case laws. So some contradictory case laws are there issued by the separate high courts have raised or given separate decisions. Some high court says that it is applicable to the contractor, or some says that it's applicable to the principal employer. According to me, during the period when the contract employee is working, then the maternity benefit is on the contractor. So the maternity benefit needs to be continued even after 1 year.
So when you say contractor, it is a employee A in this case.
Yeah.
Okay. Thank you.
Okay, thank you so much, everyone. It is now we have slightly to behind the time, so we have to move to the next session. And however, I have been putting the LinkedIn detail here, and every speaker are there. You can directly connect on the LinkedIn, have a connection with them, so that if you have some inquiries, directly connect to them. They will help you out as a refer to the people manager. Everyone, we here created the community for the helping each other. So thank you so much, Muhammad Shamil, for giving this incredible note on the, especially to the contract labor or the double dipping, how the organization can assure. Now I am here welcoming Dr.